Welcome. Delighted to be here, delighted to have you here. I'm Rebecca Scott from the Department of History and the Law School. And we are co-sponsored in this occasion by the Program in International and Comparative Studies, by the Race, Law, and History Project at the University of Michigan Law School, by the program The Law in Slavery and Freedom by the International Institute, and by the Institute for the Humanities. In the name of all of those organizations, we thank them very much and we welcome you. The purpose of today's discussion is to enhance the comparative dimension, comparative international dimension of discussions of the phenomenon of contemporary slavery. We've organized it in a sequence that is meant to capture a succession of levels from legislation through litigation to adjudication. So we're going to talk about that. In each of those levels, we are very fortunate to have with us representatives from not only 4 different countries, but also Bridgette Carr, the founder of the first ever in the United States law school clinic on human trafficking, founded here at the University of Michigan. Some of the students from that clinic, I think, are in the audience. And that's part of the inspiration for this gathering, that in addition to today's discussion, there also are working discussions going on between Bridgette and each of the representatives from other places about the possibility of developing clinics of this kind in contexts where legal education does not necessarily include components of this sort. So what I will do, we will introduce each of the 4 participants, and we will give you a sense of their background, and then we will proceed in the order in which they're listed on the program. So let me say a little bit about the 2 participants from Brazil. Leonardo Barbosa, who will be our first speaker, is a staff attorney at the Chamber of Deputies in Brazil. He is also a professor in the master's program in law that's in Brasilia in Brazil, affiliated with the civil service. And he's been following very closely the ongoing discussions about the recently passed constitutional amendment raising the penalties for the employment of labor in conditions analogous to slavery. And he will talk to us about both the process by which the constitutional amendment after a 20-year struggle came to be passed, and now the very active debate on the enabling legislation which is going to make it possible to actually enforce that constitutional amendment. Carlos Enrique Borlido Haddad is both a professor of law at the Federal University of the State of Minas Gerais in Belo Horizonte in Brazil, and also a member of the federal bench. He is known to scholars of the campaign against slavery. He's known really worldwide for having taken up his post in the district of Marabá in the state of Pará, the state which has the most intensive difficulty with labor and conditions of slavery. And he will explain to you the mechanism by which he developed the theory of dramatic justice, clustering together cases in order to move through to adjudication and, in quite a number of instances, conviction, cases for violation of the criminal statutes against the use of labor in conditions analogous to slavery. The long-term concern in Brazil had been that it was almost impossible, given a very slow judicial process, to actually reach conviction even when cases were prosecuted. Bridgette will introduce the 2 litigators, and we will then open the discussion.
Wonderful. Thank you. Marcelo Colombo from Argentina is a prosecutor and the head of the Specialized Office for Investigation of Kidnapping and Trafficking in Persons. I met Marcelo outside the United States and was immediately taken with a prosecutor who was so victim-centered and willing to think about the human dignity of victims of human trafficking and modern-day slavery. And in every meeting since, he has reinforced that position. His work in Argentina is groundbreaking. He's been willing to take a stand against public corruption and charge police officers with human trafficking. And he is wonderful and fantastic, and this panel has amazing advocates on human trafficking. Not all prosecutors in the world are as lovely as Marcelo, and so he is a fantastic example of what is possible as a prosecutor in this space. And last but definitely not least is Bénédicte Bourgeois. She's the head of legal action at the Committee Against Modern Slavery based in Paris, and she represents victims directly and serves their legal needs. She's represented multiple plaintiffs in both the French court system and before the European Court of Human Rights, and today she will talk to us about the strategies and challenges of working on these issues in the European context, particularly following some recent changes in the French criminal law. So welcome, everyone.
Great, and each speaker will speak for a little bit less than 10 minutes. That will then leave us lots of time for questions, comments, and responses from the audience. So now, Leonardo Barbosa.
All right, good afternoon, and thanks Rebecca, thanks Bridgette, thank you all for coming. So my focus here is to discuss the fight against contemporary slavery in Brazil and to discuss the legal definition of contemporary slavery in Brazil, but particularly after the amendment, the constitutional amendment that was enacted on June of this year. So according to this constitutional amendment, urban or rural real estate in which contemporary slavery has been identified shall be expropriated without compensation. And all land, property, and any goods that were employed in the illegally conduct economic enterprise is to be used to foster urban reform or agrarian reform, or also to support the prevention and repression of contemporary slavery. So it's important to say to you that this amendment is the result of a 20-year campaign that was staged by the popular movements, by NGOs, by the civil society in Brazil, by labor inspection teams, by labor courts, and by the Labor Prosecution Office, which is an independent body in Brazilian government that deals with the enforcement of workers and with collective actions aimed at enforcing those rights. So the purpose of the amendment was clearly to raise the penalties for the exploitation of slavery, relying on the definition adopted back in 2003. So curiously enough, the achievement of the goal of the amendment raised a massive legislative effort aimed at counteracting the heightened penalties and narrowing the definition. So at one side, we strengthened the punishment against the exploitation of contemporary slavery, but on the other, we're facing the threats against the legal definition that might undergo some curtailment, some narrowing. So let me talk briefly about the legal definition. According to this legal definition adopted back in 2003, contemporary slavery is present when a person is subjected to forced labor, debilitating work days, or degrading conditions of labor. It's also present when there is debt bondage, what was often called peonage. And it's also present when the worker's access to proper transportation is curtailed in order to keep him or her in the workplace. And it's present also when there are guards controlling the workplace, or documents or personal belongings of the worker are kept in order to keep him in the workplace. So the core of the controversy, because the constitutional amendment was enacted and now we are discussing the enabling legislation in Congress. So the core of this discussion, the core of the struggle, is the first feature. It is related to the degrading conditions of labor and debilitating workdays clauses. And of course, that those opposing the 2003 definition, they are worried with the fact that for them, contemporary slavery should involve any kind of curtailment of individual freedom of movement, and that's not the case. The legal definition, the current legal definition, doesn't fit the criteria because debilitating work days and degrading conditions of labor does not imply any curtailment of freedom of movement. On the other hand, Brazilian legislation, with the acquiescence of the Supreme Court, has relied on the idea that this violation is a violation against human dignity itself and not only against the freedom of movement of a person. So my quick considerations today, they will revolve around this legislative struggle. Since Carlos Henrique will provide you with more details about the meaning of degrading conditions of labor and debilitating work days probably, I will just give you a very broad idea. When I speak of degrading labor conditions, I'm talking about work sites that lack bathrooms, provide no potable water, water is sometimes muddy or shared with animals, only spoiled or very limited food is available, protective personal equipment is not provided, disproportionately low wages are paid, if they are paid at all. And debilitating work days, I'm talking about conditions of a worker being continually obliged to perform labor so exhausting that it prevents his body from recovering and ultimately jeopardizes his health and deprives him of family and social life. This is basically what I meant by these words. So I would like to advance three critiques of this idea of omitting this degrading condition and debilitating workday clauses from the legal definition. The first critique is that it is a covered maneuver. So it's basically cheating the 20-year debate on the constitutional amendment, because those who supported the expropriation clause, they did so based on a certain legal definition. And this change in the definition is not crafted to improve the idea, it's crafted to halt the movement. So those negotiations in Parliament, the negotiations regarding this reshaping of the definition, they are happening far away from the public eye and with the usual violations of legal procedure and legislative process. I can't go into that. I would really love, but this is... finally, and this is a real cause of concern for us, there are signs that the government might end up not putting a real effort in order to preserve the degrading conditions, debilitating workdays clauses, and the most startling sign that this is the case is the fact that recently one of the fiercest critics of the current definition and a former adversary of the government, Senator Katia Abreu, has been nominated for future Minister of Agriculture in next Dilma's government. So, my other 2 points, they are connected with the most common critiques aimed at the legal definition, and those are that some people say that real slavery requires control over the body of other person, the victim, and subjecting workers to degrading conditions of labor and debilitating work days just don't fit the criteria. So others will say that those provisions are too vague, they create uncertainty, and they allow the government and judicial authorities to exercise their duties on a discretionary fashion. So I think we should refuse the idea that authentic or real slavery requires the violent control of the body of the victim, and that therefore this is primarily a violation against individual liberty. First of all, and I'll borrow from Rebecca's paper, the idea that chattel slavery back in the 19th century sometimes did and sometimes did not include the fetters referred to in the Roman law of plagium, or the whips and chains so prominent in the engraving that textbooks use as icons of the institution of slavery. So it is more complex than this. And certainly even more complex if we look deep into the history of this long-standing institution. So my point is simply that we cannot take for granted a cross-historical definition of slavery. There is no authentic, real definition of slavery. In Brazil, what we are doing is that we are relying on the memory of a very strong and powerful civil society movement in the 19th century to abolish chattel slavery. We're drawing on this memory and we're trying to use this purposeful anachronism as a form of reminding us that no matter if the worker has been subjected to outrageous conditions, no matter if the worker has been treated like a beast of burden, he is not a slave. He cannot be a slave today. So my final critique is aimed at the idea that this definition is too vague, it's too broad, it creates uncertainty. So let me clarify that the current definition is written in the penal code, so it is a crime. However, if we were actually worried about criminal law here, then a critique of this vagueness would be framed like, oh, criminal statutes should provide a very clear account of the crime. It should function as a warning, a straightforward warning to people about what they cannot do. This is a crime, don't do it. Okay, but the suggestion for improvement in this case would translate into something like, for degrading conditions of labor, then we mean this, this, and that. So we would try to specify the causes and not only omit the causes. Especially what the rural bench is doing back in Brazil is they are not altering the penal code. They are creating a new definition, valid and applicable only for the expropriation action. And this new definition is the more lenient definition. So, and the interesting fact is that if we're talking about expropriation in Brazilian law, all the forms of expropriation will rely in very abstract concepts such as public necessity, social interest, and social function of property. So we're talking about abstract concepts. There's nothing new when we're discussing expropriation law in Brazil. We use this, and administrative officials that will enforce it has the duty to clarify the reasons they have to interpret the provisions in that way. So, as a conclusion, as my time is running out, I think that we're looking at a somewhat obscure political agreement. It involves giving with one hand, so I give you the heightened penalties for exploiting contemporary labor, but taking with the other. I will narrow the legal definition. The reasons advanced to do that so far, they are not sound. They appeal either to the compliance with an authentic concept of slavery that doesn't exist, or to a need for certainty that could make sense in criminal law context. We can discuss this, but definitely not in the debate around expropriation. Thank you so much.
Thank you, Leonardo. Now, our next speaker is Bénédicte Bourgeois, and she and I have in mind a linguistic duo, right? Shall we stand up so that people can see us in the back, or do you prefer to sit down?
I prefer to sit
You
down.
prefer to sit down.
Yes.
Good, we will stay sitting down. And so Bénédicte tells us that she believes her English isn't strong enough. My view is that her English is fine, but she says she'll be more comfortable speaking French, so we're going to do what's called sequential translation, which is a sort of tango, where she will utter a few sentences, and I will then utter a few sentences over them, under them, and you will all understand perfectly. Okay, Bénédicte, voilà.
Bonjour.
Good morning. Good morning.
Je vais vous présenter de manière très brève d'abord les principales actions qu'ont menées l'association pour laquelle je travaille.
Okay, she will first present in a brief way the kinds of actions that are taken by the organization she works for, the Committee Against Modern Slavery.
Sans entrer dans les détails d'abord, et si vous avez des questions, on pourra venir sur les points par la suite.
So she'll override some details because there'll be question and answer afterwards. She'll be happy to go into detail.
Donc je travaille pour le Comité contre l'esclavage moderne, qui est une association située à Paris.
So the committee is situated in Paris.
Qui existe depuis 20 ans.
It's been around for 20 years.
Et nous sommes spécialisés dans la prise en charge des victimes de traite à des fins d'exploitation du travail.
And their particular charge is to take responsibility for victims who have been victims de la traite, victims of trafficking who are being used for purposes of exploitation of labor, or exploitation.
Oui, quel que soit le secteur d'exploitation.
Whatever the sector of exploitation might be.
Même si de par notre histoire, on est quand même très spécialisé sur l'exploitation des travailleurs domestiques.
And the main group that they've in fact worked on have been domestic laborers.
C'est-à-dire que nous ne nous occupons pas du tout des victimes de traite à des fins d'exploitation sexuelle.
They have not worked on primarily, their organization is not primarily organized around working on victims of sexual exploitation.
Nos actions principales sont le fait d'aider les victimes à retrouver leurs droits, principalement par rapport via les actions judiciaires sur le terrain pénal.
So their main priority is to aid victims to recover their rights, particularly within the criminal justice system.
Même si parfois nous travaillons aussi quand même assez souvent sur le terrain du droit administratif, dans la mesure où la plupart des victimes sont des personnes en situation irrégulière, qu'elles ont donc besoin d'avoir un titre de séjour, qu'il y a des dispositions pour cela qui ne sont pas toujours respectées. Donc en général, nous faisons des procédures criminelles, mais également des procédures administratives.
So even if the primary focus is criminal activities, this often draws them into administrative law. Most of the victims are in what's referred to in France as an irregular situation, meaning they are undocumented or their documents are not entirely in order, and so they engage in it. The committee works on administrative questions as well in order to protect rights in that sector.
Et parfois, selon les spécificités des cas, nous sommes obligés aussi d'aller devant les juridictions civiles ou enfin, on est amené à faire d'autres branches de droit.
And in some cases, they also work in the civil jurisdiction depending on the conditions of a particular case.
Donc juste pour vous donner une idée, nous sommes une toute petite association, 5 permanents, 2 personnes seulement sur le service juridique et une file active actuellement de 120 victimes.
So they're a very small organization. I should say I remember going to visit up a narrow staircase to a physically small office, 2 permanent juridical staff working with something like 120 victims.
C'est-à-dire qu'en fait, nous sommes juristes, ma collègue et moi, et nous travaillons avec des barristers bénévoles qui représentent les victimes devant la cour. Nous, on fait tout le travail écrit, eux représentent les cas en cours, et nous travaillons avec une trentaine d'avocats pro bono.
So there are 2 permanent full-time jurists on the staff. They work with a group of something like 30 pro bono attorneys from the region who then act to represent clients.
Alors, les grandes lignes de notre travail, d'accord, je ne vais pas entrer dans les détails, mais initialement, comme nous avons commencé à travailler, dans le code pénal, nous n'avions pas d'infraction ni d'esclavage, ni de servitude, ni de travail forcé, ni de traite à l'époque.
So one of the great difficulties they faced from the very beginning was that the French criminal code did not contain specific articles that designated as crimes either placing a person in slavery, subjecting them to servitude, or to trafficking. So the criminal code was itself fundamentally deficient, and yet they had to work through the criminal code.
Donc nous avons dû passer par ce qui existait, à savoir deux infractions qui n'avaient pas été vraiment créées dans l'idée de forme contemporaine d'esclavage et qui touchaient les conditions de travail contraires à la dignité humaine portées sur des personnes vulnérables. C'était des mesures de protection des personnes vulnérables.
So they had to work with the two articles in particular that did exist in the French criminal code, which had not really been designed to deal with situations of contemporary slavery, but were there in the code. The first was a provision that made it a criminal offense to engage in an assault on human dignity upon a vulnerable person. So that was language that they could try to work with.
Et une autre infraction qui était de moindre importance, qui était le fait d'obtenir d'une personne vulnérable des services non rétribués.
And the second article which existed in the code was the one which made it a crime or a délit. It's a délit rather than a misdemeanor.
Les deux sont des délits.
They were both misdemeanors rather than felonies. The second one, which has proven to be somewhat less significant, was to obtain from a vulnerable person labor which was then not remunerated at the appropriate rate.
La principale difficulté a été par rapport à la notion d'atteinte à la dignité humaine. Je dois juste préciser que dans le système judiciaire français, nous avons affaire à des juges qui ne sont pas spécialisés, des juges généralistes et des prosecutors qui sont aussi généralistes.
So the first great difficulty was that the language of an assault on human dignity was one that was not defined, and they had to persuade judges who themselves were generalist judges. That is to say, they were working across the full range of criminal law. They did not have any special training in working with human rights law. Right?
Donc, en fait, dans la plupart des affaires qu'on portait, ils exigeaient un très haut niveau, du fait de cette référence à la dignité humaine, ils exigeaient un très haut niveau d'atteinte à la dignité de la personne, c'est-à-dire qu'ils disaient il faut qu'elle ait été traitée comme le prolongement d'une machine-outil.
So part of the difficulty was, since the judges didn't have an operating definition, once the possibility of using this language of assault on human dignity was raised, the judges tended to have a very high threshold. They wanted to see extremely strong proof, and the working operating understanding was often that the person had to be treated as if they were a simple machine extension of the will of another person.
Ce qui fait que, bon, on a eu au départ beaucoup de décisions relaxes.
So they had many, many cases in which there were acquittals.
Et nous avons dû aller à plusieurs reprises devant la Cour suprême.
So they often had to take cases up to the Supreme Court.
Et nous avons obtenu au final une sorte de guide, c'est-à-dire selon les spécificités des affaires, elle avait l'occasion de donner des indications sur les éléments à prendre en compte pour caractériser l'infraction ou ceux qui n'avaient pas de pertinence.
So by taking these cases to the Supreme Court, these acquittals several times to the Supreme Court, they finally did develop a kind of working division of what sorts of elements should be taken into account by the judge and what sorts of elements were actually extraneous and should not be held as required for a finding of assault on human dignity.
Et par exemple, un point très important, elle a dit de manière très claire, l'apparente liberté de mouvement de la victime est un moyen inopérant pour caractériser l'infraction.
And so one of the very important findings, and this is, I will just say parenthetically, quite relevant to the Brazilian discussion, is that the Supreme Court said that the capacity for free physical movement, that is to say, a showing of a restraint on free physical movement that impairs that capacity is not itself a necessary condition for a finding of assault on human dignity. Ça, c'était pour éviter le problème c'était extrêmement difficile de prouver qu'il y avait eu une telle restriction, c'est ça?
Oui, mais il n'y en avait pas.
Right. So just to clarify, so part of the difficulty was it was virtually impossible to prove in a given physical case of domestic slavery that there had actually been continual restraint on the physical movement of the individual. So the threshold had been set impossibly high.
Dans tous les cas d'esclavage domestique, la plupart du temps, elles font le travail domestique, mais elles sont aussi nannies. Donc ce sont elles qui emmènent les enfants à l'école. Par hypothèse, elles ne sont pas enfermées, puisque de par leur travail, elles doivent sortir.
So part of the problem was that generally people who were held in domestic servitude had among their other obligations of nannies. They were supposed to walk the children to school. So the difficulty was that in the first round of cases, the judges would say, well, she's on the sidewalk, she's walking the children to school, so how can it be that she's actually held in slavery?
Je vais peut-être aller plus vite, mais alors en fait, juste pour vous dire que malgré ses succès devant la Cour européenne des droits de l'homme, les choses ne changent pas beaucoup sur le terrain. Il y a énormément toujours des soucis pour obtenir des poursuites. Encore aujourd'hui, on a eu encore 2 échecs la semaine passée pour obtenir des poursuites qui qualifient les faits tels qu'ils sont, c'est-à-dire qu'on a la plupart du temps le travail dissimulé au lieu de ces infractions de travail contre la dignité humaine.
Okay, so one of the challenges here is that although they have had significant victories at the level of the Supreme Court, at the level of the European Court of Human Rights, and now at the level of modifications in the criminal code, it is still extremely difficult to persuade prosecutors to bring the charges on the basis of the appropriate articles, c'est ça que maintenant?
Oui.
And the great temptation of prosecutors is instead to simply bring a charge that's related to unregistered labor or the fact of the person being undocumented. Parce qu'ils pensent que c'est plus facile d'avoir de marcher avec ça.
Les deux choses. Ils sécurisent la condamnation, comme ça ils sont sûrs que les trafiquants vont être condamnés, mais il y a aussi également qu'ils ne reconnaissent toujours pas la gravité des faits portés devant eux.
So there's a double problem. I mean, this is interesting because it's part of why we have on this panel prosecutors, litigators, a judge, and people who work on legislation. Part of the difficulty is the prosecutor is tempted to go with a charge that increases the probability of conviction. And so the relatively smaller charge of causing a person to labor without properly registering the labor ensures the conviction. But more profoundly, Benedict is emphasizing, it's often because the prosecutors simply do not recognize the seriousness of the crime that's been committed. And so as they move to a lower charge to get a conviction, they're fundamentally failing to acknowledge what the actual crime is in some sense. Yeah.
Le seul effet positif, c'est qu'effectivement, on gagne davantage maintenant devant les cours d'appel.
So the only advantage of this problem is that we tend to win now on appeal, because as they make these errors, we're able to win when we take it up.
Alors juste quelques points sur la Cour européenne des droits de l'homme. Parallèlement à nos recours devant la Cour suprême, nous avons eu l'opportunité d'aller à 2 reprises devant la Cour, de gagner à 2 reprises devant la Cour européenne des droits de l'homme, qui est donc une justice internationale.
So what they've been doing in several cases is to run a parallel appeal to the European Court of Human Rights. They've achieved 2 absolute, I will add the superlatives, absolutely landmark convictions that have had an effect on all of international law. So these are the cases of CNV and the case of Ciliadin. These are fundamental cases. So as I understand it, you run these as parallel, but it can only actually come to judgment at the European Court of Human Rights once the domestic appeals are exhausted, but you can start the process before they're exhausted.
C'est des questions de procédure, je ne vais pas entrer dans les détails.
Right.
Mais
They're complicated procedural questions which she will not take the time to describe.
Les deux juridictions n'ont pas le même rôle. La Cour suprême française va vérifier d'abord si le jugement respecte la loi française et va donner l'interprétation officielle de la loi française.
So the 2 different paths of appeal have different functions. The French Supreme Court will make the judgment on whether the judges at the lower level have made an appropriate decision, and in the process they will create an interpretation of French domestic law. That's function 1.
En revanche, la Cour européenne des droits de l'homme, elle va vérifier. Alors, ce n'est pas un 4e degré de juridiction.
Right.
Il faut, pour aller devant elle, comporte une violation généralisée. Il faut que ce soit une loi qui ne va pas, soit une pratique générale qu'on peut démontrer et qui a conduit dans ce cas particulier à une violation de la Convention.
Okay, so the European Court of Human Rights does not function simply as a 4th level of appeal. In order to actually get standing before the European Court, there has to be an argument either that the law itself is violative of one of France's international commitments under the European Charter of Human Rights, or that its application in a particular case has led to a violation of one of the articles of the European Charter.
Voilà. Et donc, dans les deux affaires portées, on a pu avoir alors d'abord des précisions pour savoir comment qualifier ces faits, ce qu'on ne pouvait pas faire dans le droit français, puisque par hypothèse, on n'avait pas les concepts. Donc, dans les deux affaires, la Cour a estimé que d'abord, c'était du travail forcé, et qu'en plus, ça atteignait le degré de violation envers les droits de la personne, atteignait le degré de qualification de servitude.
So in the Sidiadin case and also CNV, in both cases, the European Court of Human Rights, looking at the way that the issue had been handled within the French system of justice, came to the conclusion that the violations had reached the level to be characterized as forced labor and even above that as servitude, and thus were violative of Article 4 of the European Charter.
Et ensuite, elle a déterminé les obligations positives des États, parce que Sidiadin, c'était la première affaire dans toute l'Europe, c'était la première affaire à être portée devant la Cour. Donc elle a estimé que l'État avait une obligation d'assurer la répression, la criminalisation des faits et la répression effective des faits dans chaque cas.
And so what the decision in Sidiadin gave was the first such decision in the whole European context of what the obligation of the member state was, both to it had an obligation to criminalize the behavior and then a secondary obligation to obtain appropriate convictions.
Et donc, elle a estimé que le code pénal tel qu'il était à l'époque ne garantissait pas les obligations de l'article 4.
And so this carried with it the conclusion that the French Criminal Code did not actually have adequate provisions to bring about enforcement under Article 4.
Juste alors, deux mots parce que
Oui.
j'ai le temps. Donc par rapport aux actions parallèlement aux actions judiciaires, nous avons des actions de plaidoyer. Donc nous avons travaillé, on reviendra dessus, en 2013 auprès le ministère de la Justice avait introduit un projet de loi pour modifier le code pénal sur la traite, mais de nouveau il avait ignoré les infractions de servitude, travail forcé et esclavage. Et donc là nous avons fait du lobbying envers les parlementaires pour qu'un amendement soit introduit dans la discussion, et finalement nous avons obtenu la loi du mois d'août 2013.
So two concluding remarks, that in addition to the direct judicial action, they've also engaged in specific lobbying on legal questions, that as recently as this summer, when the first project of what's called the proposed law was introduced to try to bring France into conformity with a whole set of decisions from the European level, the initial language lacked the appropriate characterization of slavery, servitude, and forced labor, and so the Committee Against Modern Slavery worked with the ministry to try and get a change in the project of law, and thus actually modified in the long run the French Criminal Code, because it was the modified project rather than the initial one that was passed in August of 2013.
Et un dernier point que je voulais évoquer aussi, on fait du plaidoyer au niveau européen, notamment sur la question très particulière des victimes de traite à des fins d'exploitation domestique du fait de diplomates.
So the final point, we're engaged in a particular campaign right now at the European level to try to get a specific recognition of the problem of the phenomenon of trafficking for the purpose of exploitation that is done under the cover of diplomatic immunity.
Oui, voilà, c'est-à-dire que donc, dans ce cas particulier, on doit faire face à la question très difficile des immunités de juridiction des diplomates.
So we face the real difficulty of diplomatic immunity under a variety of different jurisdictions.
Donc comme on a quand même très peu de cas à l'échelle nationale, on a fait une action de lobbying commune avec des associations, 7 associations de 7 pays différents européens.
So we're doing this in conjunction with 7 other countries. 7 other European countries.
Et là, nous avons obtenu des résultats. Le relais a été pris en fait par l'Organisation pour la sécurité et la coopération en Europe, l'OSCE, qui a fait un travail formidable. C'était mené d'ailleurs par les États-Unis, par la Suisse et par l'Autriche, qui ont fait un travail auprès de tous les services de protocole des ministères des Affaires étrangères. Et ils viennent de sortir le handbook pour expliquer toutes les mesures de prévention, mais aussi les mesures qui conduiraient à une punition des faits quand ils sont commis par des diplomates.
So we're able to end on a positive note, which is that this campaign to try to work on the issue of diplomatic immunity has been picked up by other countries and the whole European Organization for Security and Cooperation, which is now publishing a handbook that will make clear the kinds of violations that cannot be protected by diplomatic immunity. Is that?
Oui,
Thank you very much. Thank you for the extra time, because it does take a little longer with 2 languages. Voilà. So, Marcelo.
Yes.
Well, hello, everybody. It's a pleasure for me to have the opportunity to address such a distinguished and young audience. And I want to thank Bridgette and Rebecca for bringing me here. Well, I will take a few minutes to explain what I do in Buenos Aires, and also to talk about the mission and the objective of our unit there in Buenos Aires. I work as a federal prosecutor since 2008. I run there a special unit devoted to combat trafficking in person, and as a result of that, we provide technical, legal, and logistical assistance to other prosecutors throughout Argentina. We have established a clear mission in our unit, that is to reduce exploitation between human beings using the criminal law and the criminal justice as a tool. Due to that, we stress very much the importance of exploitation as a key word and as a key expression of the trafficking in person crime. For that reason, we also had the challenge, and we work hard in this, to put the federal prosecutor in the first line of action, so as they can be able to detect, investigate, and prosecute the wider range of cases in Argentina, due to the fact that this is a new crime created in 2008, and so we had to put our best efforts to train and give the skills to our prosecutors. I have selected two main objectives. First one, due to the fact that we are criminal prosecutors, we have to obtain criminal convictions. So this is a quantitative indicator, parameter, but we paid very much attention for that. We have obtained almost 155 criminal convictions in Argentina, 85% regarding sexual exploitation and 15% regarding labor exploitation. 80% of the victims are females, because of the fact that sexual exploitation occupies the more range of these criminal convictions. And we also has I like to name it like a qualitative indicator of parameters that we try to focus very much in big cases, first of all, and in cases in which exploitation does not take place without the use of violence, of the use of coercion, of the use of threat. Cases in which the exploitations occurs because of the vulnerability of the victims, because of the naturalization and the social acceptance of that practices in our societies, and because of the vulnerability as a key mean, as the most important mean. I have just 4 strategies that we have developed in Argentina, and I will explain very briefly the 4 of them. First, we had to find key allies, because we couldn't combat this alone. So we made good partnerships with NGOs. Civil sector is a very important part of this combating trafficking, because they are very helpful for us to detect a case and then to provide assistance to the victims, that is rescue in a raid, for example. We work very closely with working inspectors. They are very helpful and useful for us to detect cases, and also with the media, because we use them. We use several journalists in order to report cases and show the society which is the extent of the exploitation nowadays, and how exploitation and slavery shows currently in our society. As a second part of our strategy, we collect and assess doctrine and jurisprudence about the crime. We have a website, and then I can write it for you. Then there we will upload all the sentences we have achieved, and we also construct a tool where you can find the doctrine, the ultimate doctrine definition, for example, about the recruitment, about the transport, about exploitation, so the practitioners can use it rapidly and quickly if they have an opportunity. We also do assessment regarding the information we have be able to collect. For example, we made 2 different research about sexual exploitation and labor exploitation when we have found parameters in that cases. Thirdly, we investigate and prosecute our own cases because we provide assistance to prosecutors, but we prosecute our own cases at the same time. And we select cases under the same parameters I have told you, big cases and cases where exploitation is not so transparent because violence is not exercised. What is a big case for us? For example, a big case is a case where net of perpetrators are involved. It's a case where financial benefits have been gained by the perpetrators, and also where publications have been involved because of collusion or because of corruption activities. So we try to select that kind of cases because we found out that they are the most difficult cases to carry out to a trial. And our 4 strategy is train and teach our prosecutors, our judges, our policemen regarding a new crime and a very complex crime. For that, we divide our concerns in 3 categories, what we call the legal interpretation issues, that, for example, it's very important for us to identify which are the protected values that are behind the legal definition of the crime, because if you have to take that umbrella then to interpret adequately every element of the crime. For example, we stress that autonomy of a person, the possibility of choose a lifeline, is one of the purpose of this legal crime, but also the dignity of a person that is involved as a victim in this kind of social practices. So we think that it's a mix of both values that have to be taken account in the application of the law. Then we move forward to what we call the prejudice issues, or the preconception that prosecutors, policemen, and also judges has regarding these social practices. We found out that as we belong to a patriarchal society, we all have some kind of lack of gender perspective to address this kind of crime. So we construct guidelines to prosecutors, to judges, and to policemen in order to review their own point of view regarding some kind of social and very extended practices. For example, the brothel system, because we found out that prosecutors and judges and policemen has like a naive point of view of the brothel systems, and that not consider the extreme abuse of the women involved in that kind of activities. And as a second part, we have what we call the proceeding issues. We have made protocols to investigate financial profits. We have made protocols in order to conduct victims' interview by a proper way, so as to give the victims the proper health cares and psychological cares. Also, for acting proactive, we found out that prosecutors usually wait for the case in his or her office, so they have to move outside the office, and make relationship with NGOs in order to provide themselves cases, because cases will not knock the door of a prosecutor. And another important part for us was to make a protocol to distinguish servitude and forced labor as a modern labor-alike situation. I will talk in our presentation tomorrow about this protocol specifically. I brought some statistical information but I don't have how to put it. But to finalize, I want to tell you some goals we have achieved and what we are going to do in the future, or what are our future challenges. We have obtained, as I have said, 155 criminal convictions. That is, we believe, is a good number of convictions regarding that the crime has been sanctioned in 2008. These convictions is convictions regarding local and foreign trafficking. That's good news for us also. In these convictions, we have obtained that the judges were able to understand and analyze and interpret the crime with the dignity dimension of the crime that I have already mentioned. So I think that is a good outcome. And we have obtained forfeiture applied in a good number of cases. 34% of our cases we have forfeiture the goods and the benefits of the perpetrator. That's good. And the last, we have amended our criminal law in 2012 in order to eliminate the means as an element of the crime and from the basic legal definition of the crime, so that we are supposed to leave back discussion about consent now, but I assume that it will appear by another category or by another form. I'm not so sure about that. Our future objectives are, well, we have to obtain and get convictions regarding more big cases and more big, I think, organization, big fishes. We have to focus in that kind of crimes, of cases. We have to get a complete legal assistance to victims. We don't have that. We don't have. We have to improve dramatically our civil actions because we are putting all the efforts in the criminal sector but not in the civil sector. So we have to work hard in restitution and compensation of victims. We have to continue promoting and improving the wider understanding of terms exploitation, like I have told you, not limited to physical restrictions and or use of violence and coercion. And our main goal is to improve social equality by raising awareness about exploitative and modern conditions nowadays. I would like to finish with a quotation I like very much of one of our founder fathers in Argentina. He said in December 6th of 1810, he said this: "The freedom of people does not consist in wars, neither has to live only in papers. Any despot can oblige his slaves to sing hymns of freedom, and this mechanical singing is very compatible with the change and oppression of the people that intone it. If we wish freedom to our people, we must observe the sacred dogma of equality. This shows the strict connections between freedom, dignity, and equality, and that you might not achieve one of them if you don't reach them all as a whole." I think. Thank you very much.
Thank you. And now we'll turn to Carlos Enrique. We understand that some people need to go to class at 1 o'clock, but we will be here till 1:30. So, yeah.
Good afternoon. It's my pleasure and my honor to be here. I will talk about about slave labor in Brazil and about my experience as a federal judge for 5 years in Marabá, state of Pará, where I decided criminal cases in this topic in rural areas. When I see this warm room, in contrast with the cold weather outside, I ask myself, who is in the best position? Slaves in Brazil or slaves in the US? For me, the weather cold hurts. In Brazil, slaves work under an inclement sun. Those who work on sugarcane cut harvest up to 15 tons per day. They need to drink more than 2 gallons of water per day to keep them healthy. Do you have ever counted how much water you drink every day? Based on a Brazilian research, a person could generally be active in this activity for an average of 15 years. After the ban on the slave trade from Africa, the owners began to take better care of the slaves, and the lifetime increased to 15 to 20 years. Actually, there is no sense in asking who is in the best position. We have slave labor throughout the world, and the workers live in bad conditions, degrading conditions, so far from happiness. In the last 20 years, Brazil has made important changes to eradicate slave labor. I will talk about 3 of them. First, in 1995, the Special Mobile Group was created. The Mobile Group is constituted of labor inspectors, labor prosecutors, agents and marshals of the Federal Police and the Federal Highway Police. The conception of the group represents an innovation in terms of interinstitutional cooperation. When workers are found working in conditions analogous to that of slave, they are rescued by the mobile group, whose main objective is securing the safety and rights as workers. The labor inspectors compile infraction reports, give out work permits, they register works for unemployment insurance, and close places down when necessary. But they also have an important role in gathering evidence for criminal prosecution. They prepare a report and send it to the federal prosecutor, and a criminal case can be started. The second change is related to the amendment of the Article 149 of the Brazilian Penal Code. It's a crime if one reduces a person to a condition analogous to that of a slave. Basically, submitting to forced labor, debilitating work days, degrading conditions of labor, or restricting by any means a person's freedom movement. This is the raw material necessary to handle criminal cases. And the third last change in the last 20 years is represented by a decision of the Brazilian Supreme Court. The court ruled that federal justice would be the appropriate jurisdiction for trial criminal cases involving slave labor. Before that, federal judges and state judges were in conflict to determine the right jurisdiction. So, I have evidence brought by the mobile group. I have a crime in the penal code, and I have jurisdiction to be exercised. Then, I decided a lot of criminal cases. In my court, it was very rare a forced labor case. The arm of indigent people who work on farms is easily replaced. So, there is no need to oblige them to work. Just call the next in line. I have never seen people in chains or being whipped, but I saw too many cases involving 2 slavery-like situations, debilitating work days and degrading conditions. Defendants that submitted works to degrading conditions or debilitating work days were found guilty. If the victims work 11 to 14 hours a day for a monthly income under the minimum wage, if they have no more than 4 days off a month, if they share water with cattle, they don't have beds or sanitary installation, they are housed in tents of palm leaves, and the food is spoiled and or inexistent, they are working far below the Brazilian standards. To decide these cases, I created the Guardian Project, inspired by a concept brought up a Portuguese sociologist, Boaventura de Souza Santos. For him, the judicial system should show its best performance in high-profile cases. Cases that call attention of the media, that involves great amount of money or public resources, that touch the population closer. So, the dramatic justice has a symbolic effect. People believe that the judicial system works. With the Guardian project, I handed out the cases in progress to a particular group of civil servants, the Guardians. I said to them, let's speed up the process. Each person managed more or less 10 cases, and she had direct control over the case flow. They had to attach documents and analyze them, closely check deadlines, provide conditions to hearings, and so forth. Each case was discussed with the Guardian, and we could unify some actions. We made periodic meetings to review the progress of cases, with a report by each Guardian. Associated to this, I began to travel to other cities in order to personally conduct criminal hearings. In the end, I decided 55 criminal cases involving charges by slave labor. Usually, each criminal case has more than one defendant, and in these 55 cases, 54 people have been convicted and 42 acquitted. This is the way that I found to eliminate the slowness of the judicial routine and to contribute to eradicate the slave labor in my country. This is my Brazilian experience.
Thank you. Well, thank you all for sharing your unique and really important perspectives on this issue. We have some time for questions, so if you would please direct your question to a panelist, and you can just raise your hand and I will call on you, because I can see all the way to the back, so don't worry. Yes.
Well,
And identify yourself, maybe.
Oh, I'm Suya Caulfield, historian here at U of M, and I'm really fascinated. I'm very fascinated by the discrepancy, or what I perceive as a discrepancy in Brazil and Argentina. So I'm sorry, this is to more than one.
It's fine. It's fine. It's fine.
Because I was amazed by your statistic in Argentina that since 2008, the convictions for trafficking have been 85. Did I hear that right? 85% sex trafficking.
Yes, 85%.
And in Brazil, almost very few sex trafficking cases among the human trafficking cases. And I've thought about this in terms of debates in Brazil about the question of trafficking, whether there's exaggeration of the issue of sex trafficking because it's a sexy topic, whether in many cases what they should be, many people who represent prostitutes associations talk about the need instead to defend prostitutes' right to work and defend labor laws applying to prostitutes, and that has happened in Brazil. And I'm ignorant of a similar situation in Argentina, so I don't know what the situation is, but I'm just really amazed at the high proportion of sex trafficking cases among the trafficking cases in Argentina, and I'm equally just bewildered by the low proportion, or what I believe is a low proportion of sex trafficking cases among the trafficking cases in Brazil. And I wondered if you've talked to each other and wonder what might explain this difference?
Well, I think that Argentina has adopted the legal definition, the protocol of the Palermo Protocol, no? And that the adoption of that legal definition turns into an active of prosecutors pursuing cases that before they were not pursued under the criminal law, and they could have been pursued under the criminal law, but they sanctioned the trafficking as a standalone crime. We think that we provide new energy to our prosecutors and to our judges, and society began to speak a lot, and media began to raise awareness about sexual exploitation, about what constitutes the day-to-day in a brothel, and what is there's no like a happy prostitute and those kind of things. There was a lot of discussion in Argentina regarding this issue, and promoted basically by NGOs, but also by other prosecutors and judges and representatives. There was a lot of discussion about this, and there is a lot of discussion about this in terms of trafficking, like a trafficking umbrella brought this discussion to our society. And in contrast of what happened, we were very delayed in criminal convictions regarding labor exploitation. I think that in 2011 we had none conviction of labor. The 15% of labor convictions are regarding to 2011, 2012, and 2013. It was a very slow movement regarding this particular type of exploitation. I don't know if I have answered you.
Could I ask a follow-up before we ask the Brazilians to speak out the Brazilian case? Marcelo, is part of the phenomenon that the Brazilian Public Ministry of Labor was generating the kinds of inspection reports that could then fill a prosecutor's docket in Brazil, whereas as I understand it, in Argentina you do not have an institution comparable to the Public Ministry of Labor in Brazil, nor a National Coordinating Council against enslaved labor comparable to the CONATRAI. So in some sense, rather than reflecting deep underlying differences in the mix of forms of exploitation, it may partly be institutional because your office doesn't receive the kinds of dossiers that Carlos Enrique's court receives. Would that be a component?
Yes.
Because 0 convictions as of 2011 suggests under prosecution rather than under existence. Does that, Carlos, did you want to say something about this?
I can talk about my experience with slave labor in rural areas. The sex exploitation is not my field. But I have the impression in Brazil, at the beginning, there is some difficulty to identify who is the worker and who is the foreman or the gato.
The recruiter.
Right. Who recruit the workers. And I perceive that too many gatos accused actually were workers. And actually they are sharing the poverty. And so maybe the rate of acquittals is higher.
Actually, what Carlos is saying, I think, is something like we have internal human trafficking in Brazil. This is a very important part of the situation in Brazil because all these cases of contemporary slavery, they often involve some form of taking the worker from his origin and moving him to a far distant place where very few people can reach him. So we also have to consider that while provisions regarding human trafficking are far more recent, Brazil has been coping with contemporary slavery even if with a different definition since 1995, and that is why maybe our statistics for this are pretty high comparable to the efforts regarding human trafficking. But I guess that Brazilian policy regarding human trafficking is quite good, and it should very soon produce results in terms of convictions. I'm not sure how many convictions there are today, but I'm pretty sure that they will produce convictions very soon.
So you're partly contrasting post-Palermo Protocol initiatives, which Palermo Protocol specifically speaks of sexual trafficking, as opposed to a 20-year campaign that was specifically focused on labor.
Okay, other questions? Yes.
Hi. Thank you all so much for coming to speak today. I'm Chelsea Rosales. I'm a student in LSNA right now. I'm pursuing an international studies degree. And I just had a question about something that sort of came into my view around last year. There was a video that came out by, I don't know if I'm saying it right, Terre des Hommes. And they came out with a video about child sex tourism. And they were using technology. They created like a virtual girl named Sweetie who they used to catch people who were going on these chat rooms and like using this child sex tourism. And I was just wondering if any of you could say anything about how you've seen technology and the internet influencing contemporary slavery and its prevention, or even, I suppose, challenges to criminalizing something that's so transnational and hidden, I guess, in the internet.
Vous avez eu des expériences avec l'Internet?
C'est pas dans mon domaine, ça c'est surtout l'exploitation sexuelle et des mineurs.
Mais sur la question générale des technologies, vous avez fait un truc pour amener à la conscience le truc ludique, pour faire des recherches.
C'est de la prévention. Enfin,
Yeah, just one footnote to that, just that interestingly enough, the Committee Against Modern Slavery has actually tried to see if they can use technology for consciousness raising and prevention purposes by making available smartphone apps that make it possible for people to access information about the definition of exploitation and trafficking, so that someone who may have an inadequate understanding of the legal protections that are available can access those through technology. So that's not speaking directly to the issue of sex tourism, but it's somewhat speaking to the issue of technology.
Yes. Well, what I can say is we have started several investigations, which the case was women that were recruited by Facebook, apparently trying to offer an employed, but as was not an employed, like a model activities or model career, and with some kind of fraud offers about what they were going to do, and they began doing this in Facebook, and so I think it's in Argentina it's like a trend, using the Facebook in order to recruit. So we are working nowadays in some campaigns to raise awareness of the proper use of Facebook and don't be in touch with strangers and those kinds of things. But I agree with you that it's definitely a challenge how to deal with so many communication and opportunities to recruit. No, for us it's as
In the back?
My name is Liana. I'm a senior in LSNA, and I'm actually in the middle of writing a thesis on this subject. And I just wanted to ask, I know this is a really broad question, but if you could talk about maybe some of your ideas about root causes of human trafficking.
So why don't you start, Leonardo, and we'll give everyone just a minute on root causes. Because it could be an entire hour on root causes, right?
I don't think that I'm qualified to elaborate on the causes of human trafficking, but of course, in Brazil, there's domestic transportation of workers is not something new, and maybe it is actually something very old that has been going on, but now the internationalization of this sort of thing certainly has to do with the globalization of the world, but I know that this is a terrible explanation as such, because it's not why something is possible that is necessarily going to happen, but of course, once the possibilities arise, people that are preying on vulnerable women and maybe men, they will be looking forward to use them to actually take these persons into an even more vulnerable position, because when you're in a foreign country, maybe you don't have knowledge about the language, and somebody can hold your documents and you cannot get in touch with people at home. So my family went home yesterday and I was having some hard time to talk with them, and I and myself, and I have a phone and they have a phone too. So you can imagine the situation of a person that's actually trafficked outside the country. It really increases the vulnerability, and it increases the chances of not being prosecuted for it. I guess that's why Chris McCruden is reporting on British discussing that it's an extraterritorial crime.
Bénédicte, sur les causes fondamentales du phénomène de l'exploitation, enfin trafic dans le sens le plus général du mot,
Je vais
enfin
répondre
exploitation.
uniquement sur le secteur de la traite pour l'exploitation du travail et en France.
So speaking specifically about the question of exploitation for labor and in France,
Il y a quelques NGO en France résument la question à la fermeture des frontières. Je pense que c'est un peu réducteur.
so some NGOs have become particularly concerned with the question of linking this to closing of frontiers and immigration restrictions. But she thinks this is actually a somewhat narrow perspective.
J'ai juste une remarque sur la défense de toutes les personnes qui ont été mises en cause dans nos procédures. Toutes ont cette idée, et je pense qu'elles y croient, qu'il y a un échange de services. C'est-à-dire qu'à partir du moment où elles offrent la possibilité à une personne à l'étranger qui ne pourrait pas avoir de visa de venir sur le territoire, il y a une contrepartie naturelle qui est due de travailler pour eux.
One thing that's important to recognize is that even in the cases that we have tried, we do understand that the person who is the perpetrator generally believes sincerely that this is a reciprocal relationship. They believe this because they are under the impression that the person coming from outside the country would not have access to a visa to reach a developed country without that initial assistance from the person who will end up being the perpetrator. And so addressing this question of imagined reciprocities between people who have access to a country like France and those who would not be able to enter is part of understanding the dynamic of how these circumstances arise.
Ce qui est frappant, c'est que parce qu'il y a aussi des personnes françaises qui sont victimes de traite et en général des personnes limitées intellectuellement, des personnes vulnérables de par leur capacité intellectuelle. Et c'est le même type de raisonnement. C'est toujours, bon, c'est une personne qui ne peut pas se débrouiller toute seule, donc je vais la prendre en charge, je vais lui offrir un logement, des soins très limités, et en contrepartie, elle doit travailler pour moi.
And this is also apparent in completely domestic cases where someone who is vulnerable in part because of, in some instances, disability is taken under the protection of another individual who then exploits them with this same rationale of reciprocity.
Et je pense que la justice devrait vraiment avoir un rôle très, très ferme pour casser ce type de raisonnement et remettre les choses à leur juste place en disant que quand bien même on aide quelqu'un, ça ne donne pas la porte ouverte pour l'exploiter.
And so one of the challenges then for the criminal justice system is to try to make it clear that this imagined reciprocity is in fact impermissible, that the fact that you exercise some kind of generosity toward a person does not open the door to an infinite demand then for their labor.
I will be brief. I can't imagine another cause of trafficking beyond the economic interest, because in the both sides, the victim try to take a better life, and the traffic, the raw material can change, weapons, drugs, people, but the economic interest is the base for me.
I agree with all of you, but I think that structural inequality is the main reason, and it's connected with the sexual exploitation, because women has not equal access to rights and jobs as men. This is one part of the problem in sexual exploitation, and in labor exploitation is because they're poor people, they are illiterate, and they don't think of themselves like a person with rights, with the possibility of exercise of that right. So I think that if we can resume, I think is structural inequality and vulnerability connected with that.
Thank you. And any final question? Sure.
I'm John Ring from the Political Science Department, teaching a course on human rights this semester. So kind of two really closely related questions. First, so I did some research that's always troubled me between the difference between civil law and common law countries, but it's kind of some of the discussion that was brought up today kind of supports the idea that maybe in civil law countries, kind of the rigidity of the law makes it difficult to change and to develop into new areas of law. So I was wondering if that's really the case in France. I kind of heard that story, and was that a challenge, right, to use existing law and then to ultimately change that law? And so kind of the tie-in with the general question is, how was the European Court of Human Rights kind of, was it instrumental in that, I mean, of course you mentioned its importance, but really to the other panelists, why is there a lack of discussion of the Inter-American Court on Human Rights? And, as Argentina and Brazil are leaders in the region, are you seeing this as kind of moving into a broader regional movement, or is this purely kind of a national context in both cases?
Maybe Benedict first.
Ok, alors la question c'est est-ce qu'il y a un problème spécifique sur la rigidité d'avoir un code pénal au lieu d'une accumulation de décisions comme dans un système de common law? Est-ce que c'était un problème spécifique que vous avez dû modifier un code pénal pour commencer à avoir des inculpations? C'est parce qu'il a fait une étude comparative entre un système anglo-américain où il y a un common law qui accumule au fur et à mesure.
Oui. En fait, je comprends pas la question.
Parce que si on fait une analyse critique entre les deux types de systèmes,
Oui.
civil law, common law,
Oui.
does the civil law, est-ce que ça pose des problèmes spécifiques parce que vous êtes obligé de faire tout un changement à niveau national du code pénal pour commencer à avoir une possibilité?
Ça rejoint ce que Leonardo disait.
So this links up with what Leonardo had said.
D'une certaine manière, oui. C'est-à-dire que, par exemple, si on compare avec la loi anglaise actuellement qui fait référence directement à la jurisprudence de la Cour européenne des droits de l'homme, nous, on ne peut pas faire ça.
So in some ways, yes, having to deal with the structure of civil law and a penal code has limited us, for example, in contrast to England, where they can already begin in their jurisprudence to make direct reference to the European Court of Human Law as they accumulate the jurisprudence. We are not actually permitted to do that.
Oui, c'est-à-dire que ce côté très évolutif, où les notions actuellement qui sont en cours de construction au niveau européen, nous, en droit civil, on fige les choses par le code pénal.
So in fact, yes, in a common law system you can get a more evolutionary development of the jurisprudence, whereas it's true that under the civil law system it tends to be rigidified in stages.
Mais ça ne veut pas dire non plus que que rien n'est possible. C'est-à-dire que les notions sont toujours plus... Et le législateur cherche à faire des définitions qui sont plus ou moins larges, avec des notions plus ou moins interprétées, et ça devient le rôle de la Cour suprême de faire l'adaptation par ces interprétations.
But in fact, the contrast is not quite so stark because as a matter of practice, the Supreme Court is continually, in the French case, is continually shaping and reshaping how the language of the existing provisions is going to be interpreted. So you do, in fact, get evolution even prior to changing the penal code.
Et on a un exemple flagrant puisque juste après la décision Sigadin de la Cour européenne des droits de l'homme, le législateur français n'a pas bougé. En revanche, la Cour suprême a introduit la notion de travail forcé dans l'infraction de conditions de travail contraires à la dignité humaine.
So we have a good example of this. Once the Sigadin decision came down, you had a change in the perception. You did not get a change in the penal code immediately. The French legislature did not take steps, but the Supreme Court began incorporating that language of forced labor into the interpretation of the existing article pertaining to unremunerated labor and vulnerability.
And then the Inter-American Court question, do you want?
Yes, today in Brasilia is taking place a meeting of the American State Organization, I think, and one of the items that is going to be addressed is the creation of like an international and regional instrument of human rights related to human trafficking. If we could achieve that, we are going to be able to appeal to our courts, international courts regarding human rights in that is the Commission and the Court of International Human Rights at the OEA. But this is like the very beginning of the discussion. But we are thinking about creating a legal scenario more consistent so as to address this problem. And I can tell you that also within Mercosur, several meetings have endorsed this initiative about creating an international convention regarding states, American states.
Do you want to add anything to that?
I guess that I would like to add only that usually international courts will get involved once domestic jurisdictions are unable to perform their duties properly. And I really don't think that this is the case. At least Brazil, I can see that we have been able to conduct some effective efforts against contemporary slavery, both in administrative and judicial levels. So I can see immediately why the Inter-American Court would really get involved in trying to make a better enforcement. This is different from the European Court of Human Rights saying that legislation does not comply with the standards of the convention and such.
If I could add a historical footnote, though, of course, the case of, maybe you want to say, the case of José Pereira,
yes,
if we look at it
there's
historically, however, do you want to say something about José Pereira? Because this is, in some sense, where it all began for Brazil, right?
Yeah, José Pereira was not the first case, not the last one, but the most famous case involving slave labor. And Brazil, after the case in 1995, recognized the existence of slave labor in the country. So after that, we have a great campaign against slavery and public resources in huge quantity to try to solve the question that it's not easy.
Well, thank you all for coming, and thank you, panelists, for a fantastic presentation. And have a wonderful day. Let's thank our panelists one last time.